Hello, my name is John Milburn. Tonight I'm reviewing chapters 11, 12 and 13 of Jerry Bates' publication, Environmental Law in Australia. These chapters deal with the issues of protection of biodiversity, protection of native vegetation and protection of native wildlife. Firstly, dealing with chapter 11, we consider the way in which the Commonwealth deals with protecting its areas of jurisdiction and how the state goes about protecting areas as well. In the state context, I'll concentrate on the Queensland position. The laws which are enacted flow through from an international level where Australia is a signatory to the Convention on Biological Diversity, and as such, like other signatory nations, it is required to establish systems of protecting areas where there are special needs to conserve biological diversity and promote the recovery of threatened species and degraded ecosystems. You'll recall in the past we talked about the Brundtland Report, and in relation to that, the report emphasises a need to take an anticipate and prevent approach. So firstly, Commonwealth protected areas. The provisions of the Environment Protection and Biodiversity Conservation Act 1999 govern the way in which Federal Parliament, through the Executive, can declare and manage various types of protected areas which are under the jurisdiction of the Commonwealth. The development of comprehensive, adequate and representative national reserve systems requires a bioregional framework. And that is an area, or a bioregion is an area, which comprises a whole ecosystem or several interconnected ecosystems. And that can be categorised in a number of different ways. And these areas can be geographically separate from each other. The important part is that the control is managed through provisions which allow for prosecution. So it is an offence to take any action that results or will result or is likely to result in a significant impact on a World Heritage value of a declared World Heritage property unless authorised otherwise. A good example is Booth and Bosworth, 2001, Federal Court of Australia, 1453. And in that case, the Federal Court upheld a complaint against a respondent who was operating an electric grid system that was killing various flying foxes on private property, but within a World Heritage area. By contrast, an application for an injunction to restrain the culling of dingoes on Fraser Island because of the aggressive behaviour towards visitors was rejected in 2 Queensland-based cases. When it comes to protected areas, of course, the Great Barrier Reef is probably the best known natural feature and World Heritage property. And one of the ways that these areas can be protected is through the devising and implementation of management plans, which, amongst other things, can provide that certain activities can only be carried out in accordance with management plans. Conservation agreements can also be useful in this regard, and they can be made with any person for the purpose of enhancing the conservation of biodiversity outside Commonwealth reserves. A word of warning, conservation agreements are binding not only on the person who enters into the agreement, but also on any successors to any interest in that land of such person. You'll recall a previous video recording that I undertook which deals with the issue of searching in an environmental law context on behalf of a buyer of prospective real estate. Dealing with a state level, it's clear that states may declare an area to be protected as a reservation. The objects of reservation are much the same in all of the states and territories in Australia, and that is for the protection of flora and fauna and protection of natural features, the provision of recreational facilities, and also for education and scientific purposes. In Queensland, the Nature Conservation Act 1992 declares that the object of nature conservation is to be achieved by an integrated and comprehensive conservation strategy. Once an area has been declared as reserved, there are special rules that apply in relation to development within that reserved area. It is restricted, but it's not totally prohibited. The purposes of the development must be not incompatible with the purpose of the reservation. And reserves are often managed for multiple uses, which means that management plans may allow for different types of operations. One problem, of course, is that where you have multiple uses within a particular reserved area, there is a possibility that two or more government authorities may be responsible for management of the area and may provide for different requirements and potentially conflicting requirements in that regard. Where there is a clash of management interests, the provisions of a specific plan will prevail. Let's move on now to Chapter 12, which deals with native vegetation. Legislation has been slow to address the issues in relation to native vegetation where they arise on private land. The remedies require direct interference with traditional property rights and land management practices. That's a concept that goes right back to my early commentaries in relation to the way in which environmental law is implemented, and that's in contrast to the common law rights. So the implementation of protective legislative provisions is complicated by the potential for landowners to seek compensation for loss. Queensland enacted the Vegetation Management Act of 1999, but the Queensland government threatened not to apply the legislation unless the Commonwealth met demands from private landowners for compensation. Under that particular act, compensation can be claimed from the state where a person incurs loss or expense in complying with the requirements of the legislation or because of the exercise of powers under the Act. But generally speaking, compensation provisions are unusual in environmental legislation. So in this particular case, the Act also requires that a property vegetation management plan is accompanied by a development application for vegetation clearing under the Sustainable Planning Act. And you'll recall in previous discussions regarding IDAS that development is a very wide-ranging concept, and that can include a number of things, in this case, the clearing of land. In this context, prosecution is an important way of regulating and requiring compliance. Where one is prosecuted in relation to a native vegetation clearing issue, the defence of honest and reasonable mistake of fact, which would otherwise be available under the Criminal Code, Section 24, is taken away by the Act, that is the Vegetation Management Act, and that's Section 67B. That regime is similar to the regime that applies in relation to drink driving offences. In other words, even though you may have had an honest and reasonable mistake as to facts in relation to a particular case, that cannot be used as a defence in relation to vegetation clearing prosecutions. The use of planning provisions is also an effective way of regulating and protecting native vegetation. Land clearing can be regulated by councils as development. It can be done through local environment plans or by planning schemes, and that can effectively require the removal of trees and other vegetation can only be carried out with development consent. Failure to comply with land clearing regulations can also become the subject of prosecution or litigation. And the breach in those circumstances will not be regarded as merely trivial or technical. For example, in Newcastle City Council against Pepperwood Ridge Pty Ltd, that's 2004-132 LGERA 388, a fine of $80,000, less discount of 15% for illegal tree removal, was imposed by the court. There is another way that the executive can regulate the issue of native vegetation removal, and that is through the offset program. Offsets are sometimes treated with some degree of suspicion because they might be regarded as a device for permitting development that should really never be allowed. Queensland has developed an environmental offset policy which is similar to other states, Victoria, where the impact from the development must first be avoided, but if unavoidable, then at least minimised. But generally speaking, offsets are regarded as a last resort. It is possible to implement an offset regime through the Environment Protection and Biodiversity Conservation Act of 1999 at a Commonwealth level. The EPBCA does not directly apply to native vegetation. However, it does apply to threatened species and ecosystems and clearing of native vegetation, which may significantly impact on these matters of national environmental significance. Finally, let's look at Chapter 13, which deals with the issue of native wildlife and threatened species. The Commonwealth takes a lead role in this regard. And the protection of native wildlife and threatened species is undertaken primarily through prosecution, a theme that's consistent with what I've discussed earlier. Substantial penalties apply. Custodial sentences are often applied following a successful prosecution, but if not, the fines are likely to be substantial. So a person may not take any action which has or will have or is likely to have a significant impact on a listed threatened species or endangered community without approval. And the penalties under the EPBCA range up to 5,000 penalty units, which is $550,000 in the case of individuals, or up to 5.5 million in relation to corporations. So they're very severe penalties. Some examples. In the Minister for the Environment, Heritage and Arts against Lamatima, 2009 FCA 753, the respondent was ordered to pay a pecuniary penalty of $220,000 for unlawful clearing of native vegetation. And the orders that are made by the court may essentially be to undo that which has been done. So in the Queensland context, a case we've referred to previously, Booth against Yardley, 2006 QPEC 119, the respondent was ordered to dismantle an electric grid system which was constructed for the purpose of electrocuting flying foxes. In Plath against Rawson, 2009, New South Wales LEC 178, the unlawful clearing of land resulted in a high degree of environmental harm because of the significant extent of the clearing, and it was held that the defendant had been acting recklessly in disregard of the advice which had been provided about the way in which species were threatened, and the clearing did not receive consent, and in those circumstances there was a fine of $135,000 imposed. That in itself is very substantial, but what is really interesting is that the court ordered the defendant pay the prosecutor's costs, which amounted to more than $300,000. So in environmental law, as we discussed earlier, sometimes the costs regime can have a dramatic effect. That's all for this recording, and thank you for listening.